this review event. My name is Katy Shanahan. I am one of two co-presidents of the ACS Columbus Lawyer Chapter. Carly Edelstein is my fellow co-president. And we are so thrilled to be joined, albeit virtually, by our two panelists who we had what seems like a lifetime ago at the beginning of this Supreme Court term, Professor soon-to-be Dean Tokaji and Alana Jochum. For those of you who aren't familiar, actually first, let me go through housekeeping first. Our chat box is disabled, but you can still enter questions down at the bottom of your screen. There's two little bubbles above the words Q and A. You can click there to put in your questions. We will save time at the end of our conversation, so feel free to be dropping those in throughout the event. Now on to introductions. Professor Tokaji is an authority on election law and voting rights and all things democracy. So we will be turning to him for a lot of the cases that fall into that category, but he is also a constitutional law expert. So we will be leaning on him for a lot of other cases outside of the democracy and election realm. Like I said, he is soon to be Dean of the University of Wisconsin's Law School. So we are feeling very bittersweet here in Columbus about this event as maybe our final one with him as an OSU professor, but I'm so grateful to have him here today. And I'm actually going to be short on introductions only because there are so many good cases to talk about. So if you want to read more about the wonderful resume that Dean Tokaji has, I'm sure you can find it online. Alana Jochum is also an attorney and the executive director of Equality Ohio, which is a tremendously important organization doing work for the LGBTQ+ community here in Ohio, including their legal work that they provide to their clients. And Alana is going to talk about the Bostock case, but also a separate case that may not seem like it also includes some impact for the LGBTQ+ community, but it does. So I am going to get us started. For both of our panelists, what would be helpful for us is for each of the cases to just give sort of a brief overview of the case, what the issue is, who the plaintiffs are, things like that. Obviously, give us a spoiler, what the outcome was of that case, and maybe highlighting what some outcoming policy implications are of the case, whether it was a surprise how the Supreme Court landed up, and also particularly since a lot of these cases had some interesting lineups with who wrote either in the majority or in the dissenting opinions, to also talk about that if that is relevant. So first to you, Dean Tokaji. It's going to take me a lot of practice to get that right, but I'm going to try throughout this whole call to get it correct. I want to start with the RNC versus DNC case from Wisconsin. This case was about absentee voting. Wisconsin was one of the earlier states, like Ohio, that went into its primary election just as COVID was starting to hit here in the US. And I always joke in my line of work, I work in the redistricting space, but I always joke with our Wisconsin state director that Ohio crawled so that Wisconsin could walk and Georgia could take a rocket ship to the moon in handling elections in a very bad way in the midst of a global pandemic. So Dean Tokaji, I will turn it over to you to talk about that case.
Thanks so much, Katy. Tomorrow is actually my last day on the Ohio State University payroll before I start at the University of Wisconsin Law School on August 1st. So on my penultimate day as a member of the Ohio State faculty, it's really a great pleasure and privilege to be part of this forum, since ACS has been such an important part of my life and my career over the past 17 years that I've been here in Columbus and at Ohio State. And I guess I have to also say, on a personal note, it's a special privilege to be introduced by Katy, who's one of my very favorite former students, who I had in multiple classes when she was here. And as a teacher, there's really nothing more gratifying than when your students go on to accomplish great things, as Katy has done and is doing, and indeed as many of the members and leaders of the ACS Columbus chapter have done over the years. So I'm really happy to be here today. I'm especially happy to start by talking about the RNC versus DNC case, because it occurs against the backdrop of election disputes in both the state I'm in now, Ohio, and the one I'm going to, Wisconsin, from which that case emerged. Both of our states' primaries were affected, like several other states, by the pandemic. And indeed, in both of the states, the state leadership decided to call off in-person voting shortly before the election. Here in Ohio, I think it was rather poorly handled, despite the justifiable praise, in my view, that our state leadership has generally gotten for its handling of the pandemic. The in-person voting, as you all may recall, was called off literally on the evening before it was scheduled to occur. A similar situation in the state of Wisconsin, from which the RNC versus DNC case emerged, in which the Wisconsin governor, a Democrat, tried to stop in-person voting shortly before the scheduled primary on April 7th. He wound up being enjoined from doing so by the state Supreme Court. But the case that was before the U.S. Supreme Court had to do with a different issue. Many voters in Wisconsin, as in other states, who had planned to vote in person, decided because of the pandemic that it would be safer for them to cast absentee ballots. The problem was that a lot of people were requesting their absentee ballots very close to Election Day, which meant that they might not receive them, let alone be able to return them by April 7th, which is usually the date by which absentee ballots must be returned. As a result of this situation, the United States District Court, in order to protect the right to vote, issued an injunction giving people an extra week after the scheduled election date of April 7th, within which to return their absentee ballots. The Supreme Court, however, issued a stay of that injunction. It was a 5-4 decision, with the conservatives voting in favor of the stay and the more progressive justices voting the other way. The court's rationale was based on what's come to be known as the Purcell principle, the idea that courts shouldn't generally issue injunctions changing the rules of an election shortly before that election is about to begin. This principle was first stated in a case called Purcell, which arose out of Arizona several years ago, involving an identification requirement. What I see as troubling about this decision is that the Purcell principle, which is best considered a factor in my view, seems to have hardened into a rule, and the court's decision in this case seems to be sending a clear signal that federal district courts shouldn't be issuing injunctions, even if those injunctions are necessary to protect the right to vote, as in my view they were in the very unusual circumstances of Wisconsin's election. There's a similar case that was just decided on July 2nd out of Alabama, where again a district court had issued an injunction that required certain accommodations for voters who wished to either vote absentee or to use curbside voting. Again, the Supreme Court, by a 5-4 vote, with the conservatives voting one way, the progressives the other, stayed that injunction. So I think the signal here is that the Supreme Court is going to look very skeptically at injunctions that are designed to protect the right to vote, at least when those injunctions issue shortly before an election is scheduled to occur.
It's helpful, thank you. I'm wondering, so in the aftermath of certainly Ohio and Wisconsin's primary, and then I think maybe Georgia was next, and then Kentucky, we've seen litigation pop up all across the country a lot of which has been led by Mark Elias, who's a prominent election attorney. He's calling them as four pillars cases, attacking the difficult or barriers that exist to people being able to accessibly and safely vote this November, whether it's laws that require notaries on absentee ballots or rules about how old you have to be able to have no excuse absentee voting. So I'm wondering how you think this case fits in with all of the other election related suits that are popping up across the country, and whether you think, given how sort of narrowly tailored the decision was to Wisconsin, how widespread it could be applied to other similar lawsuits.
Yeah. So we've seen a lot of litigation really over the past 20 years since Bush versus Gore, which really opened the courthouse doors to challenges to state officials' decisions, where those decisions impose burdens on our most fundamental right, or one of our most fundamental rights in any event, the right to vote. I think this has actually been a good thing, and that on the whole, while there are lots of decisions I disagree with from the lower courts over the past 20 years, I think the courts have done a really nice job of making sure that burdens on voting, and especially ones that affect one political party more than the other, are justified by legitimate state interests. And so I'm really worried about the Supreme Court's signals in these two cases out of Wisconsin and Alabama, because I think the risk is that they will not only make litigants cautious about bringing cases that may be needed to protect the right to vote, but especially that they're going to make federal district courts and circuit courts very nervous about issuing or affirming court orders that we may need, especially in the midst of a pandemic, to protect people's fundamental right to vote.
That's helpful. I could stay on this case for hours, but in the interest of time, I'm going to move us forward to a different case. Although also still in the election space, I'd like to talk a little bit about the faithless electors case.
Yeah.
So I will turn it over to you to describe the thrust of that case and how SCOTUS ruled.
Sure. Well, this is a case, Chiafalo versus Washington, that has to do with the Electoral College, which I'm sure, as most of the people listening know, is this relic of the compromise forged at the original Constitution, under which it was the state legislatures that were given the power under Article 2 of the Constitution to determine how electors are chosen. And by electors here, I mean not voters, but those who vote in the so-called Electoral College in each of the states. And it's those electoral votes that ultimately determine who will become president. Now, for many, many years now, all of the states have adopted laws and implemented laws that allocate electors in the Electoral College based on the popular vote. Most of the states, 48 of them, allocate them on a winner-take-all basis, so that in Ohio, for example, whoever wins the most votes in the popular vote for president in our state will get all of the electoral votes. Now, the members of the Electoral College, those who are voting in the Electoral College, almost always vote as they're supposed to, right? In fact, most states require them to pledge that they vote a certain way, and 15 states, including Washington, enforce that pledge through some kind of sanction, like monetary sanctions. In 2016, there were 3 electors from Washington who declined to honor their pledge to vote for Hillary Clinton in a quixotic effort to persuade Trump electors to follow their example. So each of those 3 electors from the state of Washington were fined $1,000, and they challenged their fines on the ground that members of the Electoral College should be free to vote as they please, should be free to vote their conscience. The Supreme Court unanimously rejected that argument, with Justice Kagan writing for 8 of the 9 members, all but Justice Thomas, who concurred separately. I think the court reached the right results in this case, but I have to say I'm troubled by some of the language in Justice Kagan's opinion for the court. The main argument that those challenging Washington's sanctions made was that the word vote in the 12th Amendment, which amended the original language to Article 2, doesn't necessarily, well, that this language, they argued, connotes an independent choice, that voting by definition means you have the choice of whom you vote for. The court rejected that argument, comparing the votes of members of the Electoral College to voting as a pastor or a spouse instructs, to proxy voting in the corporate law context, and even to Soviet elections. And to me, this is very troubling language that I expect will come back to haunt us at some future date when some election rule, like, for example, a ballot access rule, is challenged on the ground that it's denying voters a meaningful choice. And I would predict that this language, that voting doesn't necessarily mean an independent choice, will come back to haunt us in some future case. I think the court could have reached the same result, saying that there's no prohibition in the Constitution on states requiring their electors to vote in accordance with the popular vote and being sanctioned if they fail to do so, without diminishing the right to vote, as I fear it may have unintentionally done through its language in this case.
Yeah, that's helpful. Along that same note about potential unintended consequences of the decision, I'm wondering if you think there are other unresolved issues with the Electoral College that this opinion potentially sort of raised to the surface, like, for example, how electors decide how to break ties, or also states that have winner take all, right? Where there isn't actually a proportionality in terms of how the electoral votes get split up in a state.
Yeah.
Connected to that in a much broader context, what impact do you think this opinion has on the growing in popularity debate over abolishing the Electoral College and moving to a national popular vote option?
Yeah, so I think the last question is really the most significant. There is this national popular vote compact that has been proposed and that a number of states have voted to adopt. The basic idea there is that the states entering this interstate compact would agree to allocate their state's electoral votes in accordance with the national popular vote. Essentially, it's a way of making an end run around the current Electoral College without amending the Constitution. There's some language in the opinion which might be understood to suggest that the national popular vote plan is constitutional, or at least to buttress that argument. For example, the court says that the Constitution gives states far-reaching authority over presidential electors, but I think the court was quite conscious that this issue was at least on the distant horizon, if not the immediate horizon, and therefore there's enough careful language in the opinion to help it avoid reaching the conclusion that the national popular vote plan is necessarily constitutional. So I'm not sure that this opinion will have that much impact one way or the other on the national popular vote plan, but it does bring what I think is, you know, honestly a vestigial organ of the original Constitution at best back into public focus. And it's important for us to remember something as well, which is that, you know, the Electoral College, as it was originally designed, was very much tied up with the desire of southern states to preserve the institution of slavery. And as we continue to talk and think about the Electoral College, we ought not forget the history of the Electoral College, and namely its intertwinement with slavery.
Thank you, and thank you for that important point. I will turn it over to Carly, who will shift our focus a little bit, and we'll let her take it away to ask Alana some questions, and then we might come back to some of the other blockbuster opinions that we got this term. Carly.
Thank you, Katie. Hello, everybody. Thank you again to our speakers. Dean Tokaji, almost Dean Tokaji, we're very excited for your big move and we're sorry to see you go. Alana, I'm just glad you're sticking around to continue having all of these kinds of conversations. I'm also sorry about the confusion before. There are not actually two of me on here. I was trying to help a coworker get in and sent her the wrong Zoom link. So I believe everything is in order now. So I'm actually the chair of the LGBT committee of the Columbus Bar Association, so that is probably an indication of where we are about to go next. The Bostick case, which was a consolidated case, 3 cases consolidated into one, was for me, I think, one of, if not one of, or not the big blockbuster case of the term. And I wanted to give Alana an opportunity to tell us a little bit about the case, and then we can delve a little bit more into the holding.
Absolutely. It's such an honor to be here. Great to see you all. Dean Tokaji, so congratulations, just so happy for you, and equally sad that Ohio has to give you to Wisconsin, but you will not be far from us in our hearts, and hope that if we continue to have virtual engagements like this, perhaps you will never leave the Columbus ACS chapter. But yes, Carly, I am so with you that the Bostock decision was really, it is a watershed decision. It is, I am so pleased and slightly surprised at the result that we got from the justices on this decision. And it was really a nail biter. I'm not sure if folks here were hitting refresh on SCOTUS blog that day, as I was and my team was, but not only did they hold us in suspense in that we did not know when in this very extending term this decision was going to emerge, but the day that it did, the very large decision that it was, 137 some pages, broke the internet, and we were sitting there hitting refresh and could not literally get the page to load. It was a problem nationwide. So all we could see for some time was that front introductory page. And so, you know, in the hurried franticness of it, I just started reading, and really when we see that one line held, an employee who fires an individual merely for being gay or transgender violates Title VII. To read those lines, you know, we're texting furiously and on the phones with our team saying, oh my gosh, I think we are in full win mode here. And it was frustrating to not be able to confirm that for some time, but really that anticipation was well worth the wait for the decision that we did ultimately get. So Carly, exactly as you said, it was a consolidated case of 3 cases: the Zarda case, the Bostock case, and the Stevens case. The Stevens case, which actually came from our own 6th Circuit. Briefly, Zarda and Bostock dealt with facts where individuals who were gay were fired. Stevens was a situation where a transgender woman was fired. And to be very clear, the facts here were egregious. These were very clear situations where folks were fired because of their sexual orientation or their gender identity or expression. And no ifs, ands, or buts about that. And the question really emerged before the court: is this sex discrimination? Is this just sex discrimination under Title VII? And the holding, I said initially I was surprised at it. This was a 6-3 decision. Justice Gorsuch penned it. So a conservative justice writing a very clear opinion saying, yes, there are no ifs, ands, or buts. This is sex discrimination. And the decision really outlines that it does not matter what the employer calls that discrimination. it's sex discrimination, and cites some earlier precedent, Manhart as one of the cases, Phillips versus Martin Marietta, and the Uncall decision. Those were situations where in Manhart, it required women to pay more into a pension because they had longer lifespans. So the employer said, no, we're not discriminating based on sex, we're discriminating based on life expectancy. And the court in that case said, no, I'm sorry, it's sex discrimination, you're treating women differently. Similarly, in the Phillips case, it was refusing to hire women who had young children. The employer might have called that motherhood discrimination, but the court said, no, it's sex discrimination. And the Uncall decision, which many of us are familiar with, was same-sex harassment. Even though the court in 1964, I think that was penned by Scalia, said you may not have anticipated that same-sex harassment would be sex discrimination, doesn't matter what we call it, it is in fact sex discrimination. So this opinion lays out then very clearly, tying this precedent into the facts that we have here. And it says what frankly advocates have been saying in our world for so long. You cannot claim that you are treating LGBTQ people differently and avoid the conversation of sex. You just can't do it. The way I had always described the circuit split before this decision was that courts were split on the subject, but they had to do legal gymnastics, in my opinion, in order to somehow disassociate LGBTQ identity from the discussion of sex. And that's really what Justice Gorsuch says here in this decision. And then they go through and acknowledge, you know, Congress may not have anticipated this. This is a quote that I liked, but the quote, the limits of the drafters' imaginations supply no reason to ignore the law's demands. They take the ordinary meaning of the term. For sake of argument in this case, they really do assume that sex refers only to biological distinctions between male and female, even though many of us have a much more broad understanding of what sex is. For this, they took that very ordinary meaning of what many people understand sex to be. And they really said that, you know, if you're not firing Hannah for being, if you're firing Hannah for not being feminine enough, or you're firing Bob for not being masculine enough, it's a violation. Even though you're treating both of those groups the same, you're still discriminating because of sex. One of the arguments that had been brought up by the opposition was, no, this isn't sex discrimination. This is discrimination based on LGBTQ status. I just don't want to hire gay people, or I just don't want to hire transgender people. I don't care if they are female gay lesbian women or male gay men. I'm just not going to hire LGBTQ folks. And the court really says no, and just flat out rejects that blanket ban against hiring LGBTQ people, saying you cannot describe transgender or gay without using sex. And because you can't describe those identities without sex, may not have been what the folks drafting the law in 1964 thought, but we interpret the broad rule. We don't read in carve-outs, ergo it is sex discrimination. So honestly, when we read this, it was music to our ears. I do think that it is a watershed civil rights decision here. I also will tell you practically in our conversations in advocacy, the fact that Justice Gorsuch penned it means something. This is really helping conservatives who frankly, I think, may in their hearts have understood that LGBTQ people are deserving of protections under the law. This is giving them perhaps some courage that a fellow member of the conservative viewpoint under the law is accepting of that as well. And so it is a really watershed moment. I saw there's a question in the comments, and I want to address that. But the other question is it a narrow ruling? And it is a narrow ruling. Watershed, but limited to Title VII in employment. So in that sense, it doesn't end the work that we need to do in other areas of the law. I'll get back to that in a follow-up for what our steps ahead are going to be. But I do just want to very briefly address the dissents. What I would call a strident dissent was put forward by Justice Alito. It was lengthy. It included many appendices and research to it. And he called the majority decision arrogant and wrong, and really said, no, homosexuality and transgender status, which he quibbled about not being defined, really are somehow different from sex, never were anticipated in 1964. Frankly, had they been considered in 1964, he does rightly, sadly, point out that they were very poorly treated characteristics at the time, more so even than now, and argues that it really undermines the court's credibility to essentially to have held this way, that really this is something for the for Congress to have taken up through the Equality Act. And Justice Kavanaugh, similarly, his decision, I would say, his dissent was less strident. It was really more, who decides this? And in his opinion, this is really the purview of Congress through the Equality Act, not the court's decision.
Thank you for that. And actually, I think that's actually a good transition. We can come back to questions about Bostock. I have lots related to RFRA and all sorts of fun things, but speaking about Justice Alito's dissent, he actually wrote the majority decision in a case that came just a few weeks later, Our Lady of Guadalupe School. It's not directly on point, but I think it has huge implications for the impact of Bostock, and I was hoping you might be able to share a little bit about that case as well.
Absolutely, Carly. That was a case that we were equally watching and very closely monitoring, because it will have implications for LGBTQ folks across the country, even if that was not related to the facts. So Our Lady of Guadalupe is a case that looks at the ministerial exception. And in that case, we had two plaintiffs, Agnes Deidre Morse Bureau and Kristen Beal. Both were teachers at Catholic schools. Both taught Catholic curriculum as part of those schools, generally advanced the religious teachings as part of the overall curriculum. But different from an earlier case that came before the Supreme Court, they did not have some sort of special title of like religious teacher or lay minister or preacher within the school structure. Both were fired because of allegedly discriminatory reasons, one because of their age, another because of complications and time away needed to address her breast cancer. And so the question really before the court here was, can these cases proceed? This is about how our non-discrimination laws generally interact with religious doctrine. And the general idea is that our non-discrimination laws apply, but they're not going to apply when religious doctrine is truly at issue. We allow religious entities under the First Amendment to be their own space, and we will not interfere, we will not entangle with religious determinations. So essentially it's do these folks fall within the ministerial exception, and therefore religious doctrine applies and they don't get the benefit of non-discrimination laws, or do the non-discrimination laws apply because they're not sufficiently religious in nature in their duties? The major case before the Supreme Court before this case was Hosanna Tabor. And that was a case with slightly more clear facts. So this is a case that deals with a little bit more of a gray area. But really what Our Lady of Guadalupe did was affirm Hosanna Tabor in its factor test. And then I would suggest it slightly expanded the ministerial exception, or at least the way that it can be applied. This case also went better in terms of my read than I expected it to. Not everybody may agree with that, but I was really concerned that the court was going to take a very formalistic view of these situations. So let me just give a quick overview. It was a 7-2 decision drafted by Justice Alito. That included some of our more liberal justices joining that decision. And it reaffirms that yes, the ministerial exception is real. It applies to non-discrimination laws of general applicability. And again, reminder that LGBTQ equality were not issues here, but we care about it because we know that those are the cases coming down the line. And it affirmed the 4-factor test of Hosanna Tabor and slightly expanded it a little. And the 4-factor test generally in Hosanna Tabor is looking at, and again, this was not a hard and fast test, and that was really reaffirmed in this case, but we're going to look and see what is the title of the person. If it's minister, that matters. It's a factor in it. Does the position reflect a significant degree of religious training or commissioning? Does this person hold themselves out to the world to be a minister? Do they Do they, for example, benefit from the tax-exempt status of a position if it's considered religious? And then the fourth one, which really became the decision holding, what are the job duties reflected in a role of conveying the church's message or the religious entity's message and carrying out its mission? And so again, the decision affirmed those four factors to be looked at, but it also said, hey, we're not going to look at this in a really rigid fashion. The Ninth Circuit had said, these two teachers should be able to move forward with their claims of discrimination because they didn't have that title. They didn't have some of the religious extensive teachings that prior cases had suggested you needed to benefit from the ministerial exception. And the Supreme Court disagreed, and they said, no, actually, we do consider these folks ministers. And the real piece they focused on was the employee conduct. They're going to focus on what is this employee doing? Are you advancing the religious purpose by teaching religion? Are you including faith as part of your curriculum in here? And here they said, yes, you are teachers in a Catholic school, incorporating prayer into your work, having some religious duties as part of the school, and generally advancing religious doctrine as part of your role. We're going to consider you ministers for the purpose of this exemption. So I said, you know, one thing that I thought this case did that I'm glad it didn't go in this direction. It could have formally said, hey, we're just going to see if your title is minister. And if your title includes minister or religious leader, we're done. You have the benefit of the ministerial exception. That's frankly the line of thinking that Justice Thomas has been advocating for since Hosanna Tabor. He has really said, as long as there is a good faith reason asserted by the religious entity, our inquiry should stop there. The court was not willing to go that far and said, no, we do actually have to look at, is this really religious in nature? And so it said, you can't just call somebody a minister and get the benefit of this, but we're really going to look at the job duties. And that said, then it did have a much more flexible application of this in this case and said, you know, it doesn't matter that you didn't have to undergo as much formal training as some folks have. We're still going to apply it to you in this situation. And that has real world results. This teacher expected to not be fired because she got breast cancer. She does not get the benefit of the non-discrimination law. Another teacher expected not to be fired because of her age, and she does not get the benefit of the non-discrimination code. So again, these are difficult cases to weigh. It could have gone much, much firmer, but it didn't. I think the questions that now remain for this are, where are the limits? Where are the limits? How would a janitor actually fare under this test? Would we say that the janitor, who I think, you know, sitting here, none of us think of as a religious position, but is it possible that it could be structured in some way that a janitor is considered a minister of a Catholic school? Or is this potentially going to expand to other religious organizations? Is there a day where Hobby Lobby, which we know has been the subject of other litigation in this realm, could somehow apply a ministerial exemptions to its cashiers? So those are going to be the gray areas of the future, but generally it was affirming that the ministerial exemption exists, and hopefully that would be applied and not differently applied as sexual orientation and gender identity are understood as protected under non-discrimination laws going forward.
All right, thank you very much. I will pass it back to Katy.
Awesome. Thank you so much, Elena, for that. Helpful always to see how these cases interact with each other and have more broad-reaching impact than one might think from the initial reading. So I'm going to shift our focus entirely and to talk with Dean Tokaji about DHS versus Regents, which is the case that upheld the DACA program. Would love to hear, obviously, an overview of what the opinion was, and I'm going to give you the questions up front so that you can answer them in your answer. The Roberts opinion in this case was a procedural one. So I'm wondering if you can talk too about what doors remain open for the Trump administration to take another stab at undermining the DACA program, and if you think that there are similarities in the loopholes that Roberts seemingly gave to the Trump administration that he also gave, quite frankly, in the citizenship question case about whether about the 2020 census, which obviously the Trump administration didn't take up, I think largely because of a timing issue, but curious if you think there are similar loopholes here in this case and what that might mean for Robert's role on the court.
Thanks, Katie. Those are great questions. Apologies for the vacuum cleaner behind me. I don't know if you can hear it, but hopefully it will be going away in a second. I think you're right, first of all, to juxtapose this case, DHS versus Regents, to the decision last term, at the end of last term. Excuse me for just a second. Could you please stop? I'm on a call right now. Yeah, thank you. In both cases, the court reversed actions of the Trump administration. The decision last term adding a question about citizenship to the United States Census, and this term the decision to rescind DACA, Deferred Action for Childhood Arrivals, a program implemented by the Obama administration. And it did so on similar grounds, that the reasons that the administration was giving for these decisions just didn't hold up to careful scrutiny. Last term, in the census case decision, the argument that they made was that we need to ask about citizenship in order to enforce the Voting Rights Act. That was an almost, well, I was about to say laughable, but perhaps I should use a more polite word. It's an explanation that I think no one really believes seriously in their heart. I mean, the real reason for adding the citizenship question, at least the main reason, was to affect the next round of redistricting, both by diminishing the number of people, especially Latinos and non-citizens, responding, and by providing a different basis on which district lines could be drawn. In this case, I really think, I was a little bit surprised by this one, and it was probably the decision this term that surprised me the most. I think the court, and in particular the Chief Justice, could have very easily looked the other way and said, well, this isn't a perfect explanation for why they're getting rid of DACA. In particular, they were citing some legal concerns about the program, but it's good enough for government work, right? I mean, I'm paraphrasing what the court might have said in this case. We don't demand absolute perfection, but instead, the majority, for which Chief Justice Roberts wrote, really conducted a pretty thorough inquiry into the reasons that the Trump administration was giving for rescinding DACA. Is this a harbinger of things to come? I'm not sure. There's been a lot written about this seeming turn towards the left, or at least the center, that the chief has engaged in this term, citing the Bostock decision that we just discussed, citing the DACA decision, and citing the Louisiana abortion case decision, which I'm sure we'll get to. I guess I would tend to be a little more skeptical about whether we're really seeing the chief turn to the center. Linda Greenhouse has a great column in the New York Times today about how, on certain things, especially issues of race and religion, Chief Justice Roberts really has an agenda. And I would add to that cases involving business, particularly in the campaign finance context, where I think the chief has a very strong pro-corporate, we might call it, agenda. So I'm skeptical of reading too much into this term's decisions, although it may well be that now that this truly is the Roberts Court, with Justice Kennedy having retired effective 2018, the chief may moderate on some issues. I would tend to explain these three decisions, the abortion case, the Title VII case in Bostock, and this decision, the DACA decision, more on the basis that it's an election year. And I think that the chief is probably very cognizant of the possibility that if the court were to issue rulings taking it in a more conservative direction, there could be a backlash against the court that could be reflected at the polls in November. I don't know whether that's the case or not, but it's at least a possibility. And I don't think the chief is particularly anxious, the institutionalist that he is, to issue decisions that he perceives as being likely to affect the forthcoming election.
Thank you for that. In the interest of time, I'm actually going to lift up one of the questions that was entered in the Q&A box, because honestly, it was a question I was going to pose anyway to the two panelists, which is, I would love for you both very quickly, since we're running short on time, and I want to hear from both of you what you think the overall themes were of this past term. Dean Tokaji, we probably won't get a chance to go full on about the June medical decision, so feel free to insert some more comments here if you think that that's helpful to sort of illustrate that point. But specifically keying in on the Chief Justice and his role that he played. The Chief Justice voted in the majority in 97% of the cases that were released or decided this term. And given how much control the Chief Justice has in deciding who writes the majority opinions when he is also in the majority, and also how broad or narrow those decisions are, I'm curious what both of you think, what to make of what Chief Roberts is trying to do and who he's handing the decisions to, if he's not the one writing them or if he is the one writing them. If this is perhaps posturing to sort of secure his legacy as sort of a response I think, Dean Tokaji, you're right to sort of bring up that it's an election year and all eyes are on this fall. But I'm curious to see what you think this does for Chief Justice Roberts' role on the court and where you think the court might be going next term.
Jump in because I'm not the expert, if this is helpful. Dean Tokaji, I'm excited to hear your real answer on this, but it is my hope that the Chief Justice is trying to secure a legacy of we are the adults in the room and we will not be politicized. And the rule of law is exactly that. It is the rule of law and no one can be above that. That was my takeaway from this term, that yes, you may be able to ultimately undo some of these things, President Trump, but we're not going to let you do it without a fight. And no, we're not going to read in the political will that you desire when clear terms like sex actually require a determination otherwise. So that is mine, and I'm curious, Dean Tokaji, for your answer on this.
Yeah, well, I do think that, as Katie's question suggests, the chief has really solidified his role this term. He is, in my view, the most powerful Chief Justice that we've had since Chief Justice Warren and possibly since Chief Justice Hughes. And his voting with the majority so frequently is one indicator of that. The chief does, I think, have certain issues that he really cares about a lot. And one of them, as Linda Greenhouse wrote today, is religion. So in addition to the Our Lady of Guadalupe case, by the way, I should say, I'm a product of Catholic schools and I actually attended Catholic elementary school in the Archdiocese of Los Angeles, where my middle school flag football team used to play both Our Lady of Guadalupe and St. James, the two schools that were involved in this case. I think that decision is one indicator of the chief and the court's lean towards giving religion a more prominent role in American public life. The Espinoza versus Montana decision striking down, in effect, the Montana Constitution's rule against aid for parochial institutions is another. There's the Little Sisters of the Poor decision, which upholds state agency rules exempting religious employers from the ACA's contraception mandate. And there's a decision coming up this term, Fulton versus City of Philadelphia, which asks the court to revisit its longstanding holding in Employment Division versus Smith that facially neutral laws that are even-handedly applied don't generally violate the free exercise clause. So religion is one of the areas where I think we see the court moving the law, albeit slowly and subtly. Chief Justice Roberts is very much playing a long game on this, and we could see more of that in the term to come.
Thank you. Another question, there's actually one for each of you both, so I'm going to give you both one last hit at the Q&As here before we wrap. So first to Alana, a question here. What might be the future implications of the court's binary understanding of sex in Bostock?
Great question, and it is one that has come up because the court used the terms gay and transgender, didn't use LGBTQ as we often as advocates do, didn't use the more broad and inclusive terms that we're used to. The question I've gotten several times is, does that have meaning? Does that somehow affect the grand umbrella of identity that we understand all of us to be part of? My read on that is no. I actually read the decision to be so clear that sexual orientation and gender identity are inextricably linked from sex without much wiggle room, that future cases may require an analysis of it, but I don't see the court really being able to veer from that. And so I do think that this decision will apply equally to transgender individuals, individuals who are non-binary, asexual individuals, somewhere within the broad, beautiful spectrum that we have. So I don't actually read that as impacting that, and general consensus that I've been in discussing this with attorneys who are in this area, we're generally on the same page of not seeing that as a factor. And then one piece I just want to leave with is that I did say it's a narrow ruling, and it is. It is only talking about federal employment law. It does not immediately translate to housing or public accommodation. It does not obviate the need, for example, the Ohio Fairness Act here in Ohio, which would add protections in all areas of Ohio's non-discrimination law, including employment. The federal jurisdiction level is 15 or more employees for Title VII. Ohio, it's 4 or more employees. So we actually capture many more of those middle and small businesses. So a great watershed ruling, but we have a lot of work to do still.
This final question is for Dean Tokaji, and then we will wrap. Are you surprised that the Supreme Court declined to take up any of the coronavirus-related election litigation? So, for example, the absentee voting case down in Texas, or ballot access, other ballot access cases around the country?
Not terribly. I feel like they did enough in the two cases they did take, quite honestly, to send the signal that they want to send, which is a signal, as I mentioned earlier, that district courts should be very reluctant to issue injunctions protecting the right to vote close to when an election is about to start. I think the court has sent a very clear signal on that, but in my view, an unfortunate one that tends to magnify judicial restraint at the expense of the right to vote.
Thank you again to both of you. I know I suggested there were a bunch more questions related to Bostock and the LGBT cases. We will just have to wait and see what the court takes in the coming terms. I'm especially curious to see what happens with the Religious Freedom and Restoration Act as it applies in this context, especially because it seems like there's a holding in the Sixth Circuit decision that now applies in Michigan, Ohio, Kentucky, and Tennessee with respect to RFRA. But again, thank you so much to both of you. Dean Tokaji, good luck. And Alana, I am so looking forward to actually seeing you in person at our next ACS Columbus event.
Can't wait for it, everybody. Thank you so much.
And one just final word of thanks, obviously to both of our panelists, not only for joining us for the review event that we did, or the preview event that we did so long ago at the beginning, but for also being here to wrap it up. It's good to have you both back as good bookends to this historical and odd term that ended virtually and late in July, but particularly to you, Professor Tokaji, a huge note of thanks for everything that you've done for us, not only as the ACS Columbus chapter, but also the ACS Moritz chapter. I'm also an alumni of that. You were so integral to the growth of that chapter at Moritz, and certainly then dovetailing into the Columbus chapter, since many of our past and present leaders are former students of yours. Your work here in Ohio is just, we're so lucky to have you in our backyard, and I am feeling very bittersweet about this moment. We are so looking forward to your next chapter in Wisconsin, though we are so sad to have you leaving Ohio. So I am feeling endlessly lucky to have gotten you while you were at Moritz. The 5 classes that I took from you, I will always say were not enough. I can never get enough of hearing from you. So I hope that you will still take our calls and asks to join these events in the future. We wish you nothing but the best in Wisconsin. I'm so envious of the community that you are about to join. They are absolutely lucky to have you. So again, thank you so much for everything that you've done for us here in Columbus and in Ohio. We can't wait to see what you do next as Dean. And to all of you who are joining us virtually, we obviously wish so dearly that we could have been together in person, but virtually we'll have to do for now. So until next time, be well, stay healthy, wear your masks, wash your hands, make sure that you have filled out your census and that you are registered to vote at your current address and that you go out and vote. Thank you all so much for joining. We will see you soon.
Thanks, Katie.